All right, I believe we can begin now. And at this time, I will call up for argument in the Kansas Court of Appeals, the matter of 119981, State of Kansas versus Bradley M. Trefethen. And I'd like to welcome you all to this virtual oral argument. My name is Mike Boozer. I'm the presiding judge for this argument. And joining me today is Judge Steve Hill. And Judge Hill needs no introduction because I believe he is 22 years as a district court judge in Miami County and 17 years on our court that's qualified him as the longest serving judge, living judge, in Kansas. So that's—
I can verify I am still alive.
And he is not a cardboard cutout. And their other panel person is Judge Sarah Warner, who is notorious for being our newest member of the Kansas Court of Appeals, and we love having her. She has just been appointed in 2019, and she comes to us from private practice in Lawrence, Kansas. And so that is the other third of the panel. My job is primarily to keep time here today. And as you both counsel know, you have 15 minutes per argument on the appellant. You have rebuttal time, and I'd like you to tell me at the outset of your argument how much time you would like for rebuttal. And with that, I believe we'll get started. So we'll start off with Mr. Latta.
Thank you, Your Honor. And can Your Honors hear me all right?
Yes.
All right. Well, good morning, and may it please the court. James Latta, representing Bradley Trefethen, and may it please reserve 3 minutes for rebuttal.
All righty, that's fine.
Thank you, Your Honor. Today, I was only planning on talking about my issue 1, and I'm going to stand on my briefs for the remaining issues, unless Your Honors have any questions, of course. And so for issue 1, as I know this court knows the facts very well, I'm going to jump straight into the state's argument that recklessly causing the aggravated battery, recklessly causing great bodily harm, that recklessly only applies to the result. And so as simply as I can put it, we know from the O'Rear case that when the statutes were written nearly identical, recklessly causing great bodily harm and intentionally causing great bodily harm, that the mental culpability applied to the act. So our Supreme Court's already held that. And then, of course, the state relies on the new definition of recklessly to try to say that recklessly now only applies to the result. And so the simplest way I can put it is, as soon as you go to the definition of recklessly, the third word in the definition is acts. A person acts recklessly when such person consciously disregards a substantial and unjustifiable risk. So the definition to me already, in the plain language, already contemplates that recklessly can apply to an act. We know recklessly is an adverb. Recklessly modifies an action, and in this case, the action's causing. So I don't see how we can say that recklessly causing only applies to the result in this case. And so the state, they argue about the murder statutes and how the result there is the killing, and so that those cases. But the killing is, to get to a killing, you have to have some type of harm. So the harm can be any way in those murder statutes. It could be intentional or reckless. But the result, the killing, must be reckless. In this case, though, the harm and the result are the same thing. The statute says great bodily harm, meaning that there's no way to get around the result. The action has to be recklessly because the harm and the result in these aggravated battery statutes are the exact same, unlike the murder and involuntary manslaughter statute. So the state cites Hobbs, talking about how our Supreme Court held that knowingly causing applies to the action. and the result. And so I think another good point from Hobbes is our Supreme Court's always held that these mental culpabilities apply to the underlying act. All Hobbes did was extend it to the result based on the knowingly definition. So so the only thing new is this reckless definition, and it clearly contemplates the action goes to the result. And my two final points is I'm not sure the state really knows what it's asking for, because if we say that there's no mental culpability to the action in these recklessly aggravated batteries, then I don't see what's the difference between a knowing battery and a reckless battery. They're going to be the same in every case. And in every case where they charge a defendant with knowing aggravated battery, they're going to get a reckless lesser in it. If you say that any action can cause a reckless battery, so when we think about knowingly, the result, we must be aware.
Counsel, I have a question for you.
Yes, Your Honor.
If we accept what you are saying as true, that the recklessness aspect applies to the act and not simply to the mens rea, then in what circumstances would we ever have reckless conduct?
I think our courts have already found it. Whenever someone is not intending the action, if someone's waving around, if someone's joking around, spinning a pistol around in their finger, and then the trigger accidentally goes off, and there's people in the room, they didn't knowingly or intentionally pull the trigger. That was unintentional, but they disregarded the substantial and unjustifiable risk of spinning a gun around in a room of people. So any type of unintentional conduct when the underlying act's not intended, that would be reckless conduct.
But even in that circumstance, the person intended to swing the gun around, right? There was still an intentional act that led to the conduct. And so how can we get around the language of the statute, which says that there has to be an act, and then the intentionality is whether you recklessly cause the harm?
I mean, I would disagree a little bit respectfully. I think the underlying action is the trigger pull. So that's how I would distinguish that. And so I think our Supreme Court has held unintentional acts before, such as intentionally firing a gun into the air, but not intending the action of hitting anyone.
But in that circumstance, there's an intentional act and an unintentional harm, right?
That's right. But the act, though, was still unintentional. So that there was an intentional act, but the culpability with that act was unintentional. They did not intend that action to cause any result. So
How is that different from this case?
And because I don't see how you can unintentionally yank someone off the bed. So to me, that would mean that it has to be intentionally or knowingly. So I don't understand how someone could, to me, the action has to be reckless, and that's unintentional. And so it's not even possible to unintentionally. I mean, it's not like my client was running in the room and he slipped and fell, and then when he was trying to catch himself, accidentally, without thinking, grabbed the leg. I mean, I still think the mental culpability has to go to the action. Just because all of our actions, just because our body is moving or doing something, I don't think we necessarily have the intent behind the action in every case. And so I think to say that we do would just, I don't see how we'd have any difference between the reckless aggravated battery and knowing aggravated battery. They'd be the same thing to me.
Well, counsel, I have a question for you. It seems to me now that you are arguing that it's the mens rea that reckless applies to, not to the act. Isn't that what you just said?
And when you, to the result, I mean, it could apply. So when you say mens rea, do you mean the result, the aggravated battery?
No. How the act was performed. What was the mental state of the offender when the act was performed? Isn't that the mens rea?
Yes, Your Honor. And I think it applies throughout the statute. I think it applies to that as well, and also the underlying action. Similar to how the Hobbes Court applied it throughout.
Well, the difficulty is when you're dealing with recklessness, and intentional touching. And that's your fundamental argument. And I was intrigued by your last argument in your brief, where you say that the statute is a logical impossibility. Am I misreading your argument?
No, based on the way based on the way it was instructed was my argument, because they say that the definition of battery includes intentional, and that's how this jury was instructed in this case. And so I don't see how you can tell the jury the battery must be conducted in an intentional manner, and at the same time, we're going to say that it's unintentional. And as your honors know, our Supreme Courts have said that those kind of logical impossibilities can't stand. That was my main argument there.
All right.
There's no other questions, Your Honor. I would waive the rest of my time and just ask this court to please reverse my client's conviction.
All right. Thank you very much, Mr. Latta. You will have 3 minutes in rebuttal. And that brings us to Mr. Lance Gillette, representing the state.
Good morning. Thank you, Your Honors. May it please the court. I'll also focus primarily on issue 1, although candidly, I think that issue 1 spills over, as this court just hinted at, into virtually every issue in this case. And I think that I would start by just reminding this court in Deal that our Supreme Court has recognized that there are 2 different kinds of reckless act. There is the blind conduct, which I think Mr. Latta is talking about in regards to the act. But that's not the only way that recklessness can be demonstrated. Recklessness can also result from an intentional or knowing act, so long as the result was reckless. And I think that that definition has to be applied here. Mr. Latta would primarily rely on O'Rear, but his own brief points out that the applicability of that case is at best substantially in doubt. We have a completely different set of definitions for the mens reas in Kansas than we had at the time O'Rear was decided, and that has been recognized by courts multiple times now. Specifically, the Wilmer case was one of the most recent, but I'd also note that that Chavez, another Supreme Court case, they note that O'Rear's logic is valid because there is a factual impossibility, because an act cannot simultaneously be reckless and knowing and intentional or, but because of the way that we have changed the definition of mens rea in Kansas, it is legally possible. And the question then only becomes, it's legally possible for a person to be guilty of a reckless act by knowingly or intentionally committing the same act. The question again, it's the result. And here, the result is great bodily harm. And so I think that the evidence in our case comports with the modern definition, the only definitions of culpable mental states that apply. I guess the last thing I would say about O'Rear is not only were they different, but at that time, the Kansas statutes required, they obviously required a mens rea, but there were only 2 choices. It was intentional or reckless. And the intentional definition at that time encompassed knowing. And they were at that point at least mutually exclusive factually. And I don't think that that is the case anymore based on the way that Kansas has redefined the culpable mental states. And I think that the
Counsel, I have a question. Is it possible for us to accept your argument and decide this case in a manner that is consistent with this court's previous decisions in 2018 in Ochoa and then in Frazier in 2016?
I think that there is. And the point that I would like to make regarding Ochoa, Frazier, Hunt, there are a couple of cases that were cited in the briefs, is that in those cases, this court was interpreting 5202C again to determine whether or not it automatically allowed for a lesser included. And the answer to that question is ultimately legally, yes. Factually, no. And I think that's the point of the holding in Chavez that explains that. It is legally possible, but there's always the question of whether or not it's factually appropriate, because to give a lesser, as was done in this case, it has to be both. And here we have ample evidence of that from the defendant's own confession. So the short answer is yes, and I hope that explains why. Are there any other questions on that? Okay. I want to also keep in mind when we're talking about issue 1, we're talking about the sufficiency of the evidence, and I don't want this court to get confused about what the standard of review is here. The standard of review is whether or not this court can be, whether or not this court can be firmly convinced when looking at the evidence in light most favorable to the state, that whether a rational fact finder could have found the defendant guilty beyond a reasonable doubt. Frankly, I think that the defendant's claim to this end is to some degree a non sequitur, because he acknowledges that the state and the defendant's theories was that the evidence tended to prove an unintentional or unknowingly, that no evidence support that Trevathan acted recklessly. And I just don't think that's the appropriate way to apply the statutes regarding mens rea, as I've already described. Because again, reckless crimes may involve deliberate acts, and that's from James and Deal, controlling language from our Supreme Court. I also wanted to, I guess the final note on this is that the defendant wants to try to draw some distinction between reckless aggravated battery and the reckless second degree murder or reckless involuntary manslaughter statutes. And I don't think that distinction exists. When we look at those statutes, they're virtually the same. There's no way to distinguish them, and I don't think he even tries. So I think that the reasoning from James and Deal has to control here. I guess the last thing, unless there are additional questions, I want to make sure that, again, that this court considers each issue individually under its appropriate standard of review, and that it sees that while this issue regarding 5202C is spread out and made a number of different ways, the standard of reviews are different each time. Defendant's constitutional claim, I don't believe, is properly before this court, and I hope that the court sees it for what it is. I also,
Counsel,
yes.
May I interrupt you for just a second? Although Mr. Latta did not argue some of the other issues that he raised in the brief, I wanted to get your reaction to one of those issues, and that's the instruction that was given that we have in Kansas, where the higher degrees of culpability include the lesser degrees of culpability. And so an intentional act includes recklessness. What is your reaction to that argument?
I guess in what sense, if I could ask Your Honor, on which specific issue and in what sense are you asking that?
I can't remember exactly which number of the arguments that Mr. Latta raised that in, but I was intrigued by it and I wanted to hear your particular reaction to it. Is we give an instruction in Kansas that says, intentional includes knowing includes reckless, And is that right? Is that true? I guess if the legislature says that's the policy, that's what we have to live with. Is that what you're saying?
I think that, yes, I think that this court must faithfully apply the legislature's clearly stated intent. And to answer your question, I believe I note in the brief that what we're talking about here regarding a mens rea is a sliding scale. And at the minimum, we can have reckless as far as a culpable mental state. But if there's knowing, then that it automatically has proven a higher level of mental culpability that would encompass the lower. Same thing with intentional. I don't think that there's any inherent conflict in that because of the sliding scale nature of that.
So if I understand your argument correctly, if the state here proved an intentional act, then they automatically proved that this was a reckless act?
No. Again, this comes down to the split on whether or not it's legally possible versus factually. And so if we've proven an intentional act, the question then remains about the outcome. And here, there was no evidence.
So that instruction wasn't necessary here, is that right? Because you're arguing that it's different. That recklessness is different than what the instruction gives. You see my point?
I'm trying to, but I don't know that it is necessarily, because of the fact that that instruction specifically refers to the act. And so I guess maybe what we're doing, maybe we're splitting hairs over what the act actually is here. Because I think that the act encompasses the result, to be perfectly honest, as does the acts in the murder cases.
Well, as I understand the act here, is the man grabbed the boy by the legs and for whatever reason lifted him up, and he broke both legs. Is that correct?
That's correct.
And that was an intentional act. It wasn't an accident.
It was at least knowing.
Okay. And so that would include, under this instruction, that it was reckless.
Yes, it would have been sufficient proof that his mental state was at least reckless. Yes.
Okay. But that's not necessarily what that instruction says, is it? Proof of that means it's reckless. Does it bleed over? That's my concern.
I think that like I said, I think that the only bleed over here would be any concern about the sliding scale regarding the culpable mental state. And I don't think that there is any problem with that, even if there were some bleed over. And again, I think that the question then would become, if you're discussing issue 2 and whether or not that creates a mandatory presumption, it does not. It's just basically telling the jury that if there has been sufficient evidence shown of one, then they can take that or leave it as far as whether or not it proved the lower. It tells them that they should. And again, I think one other point, if I could, Your Honor, and I don't know if it's directly answering this court's question, but to get to that in this case, the problem that the defendant runs into is that based on the facts and the evidence in this case and the jury's verdict, there's actually no way that the jury would have applied that statute or that rule here. Based on the jury's verdict, we can conclusively determine that they did not find intentional or knowing action. As we presume they followed their instructions, if they had found intentional action, they would have convicted the defendant of knowing aggravated battery. If they had found knowing action, they would have convicted the defendant of knowing aggravated battery. Here, they only convicted of reckless, which I think firmly establishes that the jury found only recklessness based on the facts of this case, and that verdict has to be upheld here.
Thank you, counsel.
Thank you. If there are no other questions, I just would leave the court with the fact that I think that the evidence in this case was strong. I respectfully would concede that my brief is not the cleanest as far as addressing each of these issues, but I think that the standards of review at the very least are appropriate. And I would just urge this court to apply those standards when viewing each of defendants' claims individually in their own right, and find that there was no error in this case.
All right.
Thank
Thank you very much, Mr. Gillette. Appreciate your argument. Mr. Latta, 3 minutes for rebuttal.
Thank you, Your Honor. The only thing I have on rebuttal is going to what Judge Warner said about some of the other cases, Ochoa and Frazier, is I would just respectfully ask this court to take a look at this case from a different point of view, that if the jury had only been instructing on knowing charges, and I was sitting here arguing that a reckless instruction should have been given, I believe this court would find that to be factually inappropriate for insufficient evidence, as showed by the unpublished cases I cite in my brief. And unless there's any other questions, that's all I have, Your Honors.
Counsel, I do have one question. And that is, in what Judge Hill was just discussing with Mr. Gillette, is there any possibility that the instruction regarding kind of the Venn diagrams of intentional acts and intentionality, knowing includes intentional includes recklessness, did that play any role here?
Well, so I certainly think it did. I don't see how it couldn't. I mean, in my view, the only evidence is that everything happened was either intentionally or knowingly. And this instruction tells the jurors that once they proved, I don't see how it's not a mandatory presumption. It just tells the jurors if they prove intentional, that then they prove knowing. It doesn't leave any room for rebuttal or for them not to accept that. So
But here we know that the jury found that there wasn't intentional or knowing action, right?
I think that instruction to get to recklessly, they could have found intentional and then said, well, if they found intentional, they've also proved recklessly according to that instruction. And so we said, we think this is the right option. I think that instruction allows them to do that. I hope I answered your question, Your Honor.
Thank you.
All right, if there are no other questions, that'll conclude the arguments in this case. Thanks to both counsel for their arguments, especially in the internet. Very, very interesting situation we've got here. So thank you very much, and we'll give this due consideration and get out an opinion in due course.
Thank you, Your Honors.
Thank you, Your Honors.
All right, I believe we have everyone. So we'll call up the second case. And the second case this morning is 121564, Charles Sander, appellant versus the Kansas Department of Revenue. Counsel, you each have 15 minutes for your argument. For the appellant, I'd like to know how much time you would like to have in rebuttal. And I guess we're ready to proceed.
Your Honor, may I please have 1 minute for rebuttal and 1 minute warning?
Okay, I'll do it. And you are Mr. Walter?
I am. I appear for Charles Sander, the appellant.
Very well. All right, you may proceed, Mr. Walter.
Your Honor, most of what I have to say is in my statement of facts. This is what in our office we call the wristband case. The events which give rise to this argument occurred on July 15th of 2018 in Hays, Kansas. Kind of dumb to drive at night and not stay in the speed limit, but that's what my client was doing. He was driving 30 and 20. Police officer who were engaged with emergency device and pulled in beside Sander after about a block. As he approached Mr. Sanders' vehicle, he saw an open bottle in the console. He admitted it could have been empty. He did not ask. He did not visually inspect. He didn't know if it had alcohol in it, or in fact, if it was a spit bottle, which some people use for chewing tobacco. He asked Mr. McClure asked Mr. Sander for proof of his insurance and driver's license. Mr. Sander produced both without difficulty. Officer McClure admits that Mr. Sanders' speech was not slurred. He had no difficulty communicating. Nevertheless, Officer McClure asked Sander to exit his vehicle. While doing so, Sander exhibited no problems with balance or coordination, and at no time did he admit to having consumed alcohol or drugs.
Counsel,
Yes, sir. Yes, ma'am.
I'd like to stop you right there before we go on to what happened after that and just look at the facts from the perspective of the officer at that point, which, wouldn't you agree, that's our standard, that we look at those facts on appeal?
We look at the totality of the circumstances. I agree. And these are also based on the findings of, both sides asked for additional findings of fact. And these are basically the same facts that are contained in the findings of the additional findings of fact.
And is it my understanding you're not claiming, your client's not claiming that those findings aren't supported by the record, right? You're agreeing that those findings are supported.
Yes.
Correct?
Yes, Your Honor.
You're just disagreeing with the administrative law judges and then the district court's weighing of those facts, if you will.
Correct. The only thing that I would add to the statement of facts is that part of the reason that Officer McClure asked Mr. Sander to get out of the vehicle was because he observed, I believe it was a yellow wristband on his arm, which indicates that you are allowed to enter into an establishment that serves alcohol and consume it if you want to. Doesn't necessarily mean that you entered into the establishment and drank. You could have entered into the establishment and put on a wristband simply because you were a designated driver. But if you go into one of those places, you have to put one on just because you decide to drink. And that's part of the reason that Judge Biddle cited in his additional findings of fact that supported the probable cause for Officer McClure to request that my client take an evidentiary breath test. He saw the wristband, he saw the bottle in the console. He didn't know whether it was full, whether it was empty, or even whose it was. He simply asked that, and the fact that he was wearing the wristband to get out of the car. Go away.
Counsel, can I stop you one more time? I just have a factual question
Yes,
for you. And that is that in the department's brief, the department indicates that at some point we learned that the bottle contained beer. That was not at the time that Mr. Sander was in the car or exited the car. Do we know when? Is there any place in the record where it says when the officer learned about the contents of the bottle?
I don't think there is. I reviewed the record again this morning, and I don't believe there is anything that indicates when he viewed the contents of the bottle or if he viewed the contents of the bottle.
Thank you.
Anyway, he took him to a parking lot, administered some field sobriety tests. Once he took him out of the car, it's my position that he was basically under arrest or otherwise in custody. And he had him imagine a line in the parking lot for the purpose of administering the standardized field sobriety test, the walk and turn and the one leg stand. The only thing that he talks about in the walk and turn is my client having deviated from the imaginary line around an inch or an inch and a half. Did say that he was less than satisfied with the performance of the walk and turn. He then administered the one leg stand. I think all of the evidence in Judge Middle's additional facts indicate that he exhibited no clues on the one leg stand, which leads me to say that I need to correct a portion of my brief, which appears on page 9. I think I said one clue on the one leg stand. It should have been none, because every place else in the record said none. And that is in fact what Officer McClure testified to. So if you take the wristband out of the equation, our position is that number one, he didn't have grounds to remove him from the vehicle. He had to check his license and registration, give him a speeding ticket, and send him on his way.
Counsel,
Yes,
it's my understanding that on an ordinary traffic stop, we have said on many occasions that it is permissible for an officer to ask an individual to step out of the car and either stand beside the vehicle or sit inside the police officer's vehicle, and it would not constitute an arrest. Is that that apparently is not your understanding?
not in this case, Your Honor. In many of those cases to which you refer, the officer had smelled the odor of alcohol before he asked him to exit his vehicle. In this case, the officer testified that he did not notice anything except a moderate odor of alcohol as he was administering the field sobriety tests.
And let me ask you another question, and that being, do we really, since this is an administrative proceeding to suspend a driver's license, should we really be looking into the constitutionality of that original encounter, whether or not the officer had sufficient grounds to stop and question your client? We've got Martin versus Kansas Department of Revenue that says, really, you can talk about it, but we're not going to do anything about it because this is an administrative function and the exclusionary rule doesn't apply. What's your take on that?
My take on that, Your Honor, is I believe the answer is in KSA 8-1020. It says the constitutional issue can be raised at any time. I've raised it in my brief, and I raised it during the administrative hearing.
All right.
Well, I'd like to follow up on, if I could, Mr. Walter. Can an administrative agency rule on constitutional questions? Do they have such authority?
No, Your Honor. At the initial hearing before the administrative law judge, I think 8-1020 specifically says they don't have authority at that hearing to do that. However, once you file a petition for review, you get before district court, I believe at that point, you can raise the constitutional issue or even as late as this.
Thank you.
But you are correct. The administrative law judge did not have the authority to rule on the constitutional issue.
Counsel, who had the burden of proof, both at the administrative proceeding and before the district court?
Mr. Sander,
And on appeal, whatever inferences, if there are, if you will, innocent and culpable inferences that can be drawn from the facts, it's our duty to draw those inferences that support the decision below, correct?
I respectfully disagree with that. This is the standard of review in this case. The question of mixed law and fact. And I think you have the right, Your Honor, to take a look at what are basically undisputed facts in this case and decide whether there was probable cause to request that Mr. Sanders submit to an evidentiary test.
And in making that determination, if we're drawing inferences, we draw those inferences in support of the determination below, right?
I'm not aware of a case that says that.
All right, Mr. Walter, you have 1 minute before your 14 minutes expires.
I'm finished, Your Honor.
Okay, thank you very much for your argument. Mr. Bradley?
Thank you, Your Honor. My name is Charles Bradley. I'm an attorney with the Kansas Department of Revenue, and I'm representing the defendant. Mr. Walter is forthright and honest about the facts of the case. They are presented in the findings of fact filed by the court, and they really are undisputed. It appears that the only argument as per the facts is the weight given to them, which quite clearly the Court of Appeals is not to reweigh the evidence of the district court below. The findings were as stated by the district court. They were weighed as the district court weighed them. And really the only thing that this court should or could be doing is seeing if there was substantial competent evidence to uphold the district court's decision. But I would like to kind of extrapolate on Judge Warner's point that at each level of this, the plaintiff is bearing the burden of proof. This court is not to look at the facts that were available to the officer at the time and determine whether he made the right decision. The district court is to look at those facts and see if the officer made a reasonable decision. And this court is to look at the district court to see if it made a decision based upon the facts. At each level of this, it becomes a bigger and bigger burden. There are two of the facts that I'd like to go ahead and clarify on. As far as the bottle in the front cup holder, the point that I listed in the brief indicating that there was alcohol later, that was within the police report. It was found after they locked up the vehicle and did all that. It should not be considered by the court. It was after the arrest. It was not within his purview at the time. However, the issue of the bottle, even if it was empty, even if the officer knew that it was empty, it's still an indicator of possible impairment. But at that time, all the officer saw was a wristband, bloodshot eyes, and a bottle. And at that point, the officer had to
Well, you had
wonder,
more than that, didn't you, counsel?
and this is just at the initial stop. This is before he said anything, any sort of interaction.
But you had the lateness of the hour.
Oh.
You had the speeding. You had the location.
You are absolutely correct, Your Honor.
All of those things can be considered by an officer, correct?
Correct. And in that immediate instance, there's no probable cause. He doesn't have to prove that he's under the influence. All there really has to be is something he can point at to make him think there might be some sort of criminal activity. And honestly, with all of those things that you just listed, it's reasonable to think that the officer at least thought that he may be under the influence. And that's all that he's trying to think at that point. Because we're not proving that any of these indicators are illegal. It's not illegal to have a wristband. And there are innocent explanations for almost every indicator of impairment. Bloodshot eyes could just be tired or looking at the field for a day. Again, if he had the wristband, he could have been the DD that night. But the officer has to go off of what he sees at the time to try to protect the streets. All he's trying to do. I believe the other issue was the validity of the wristband, using it as an indicator of impairment. State v. Knopp has held that the presence of a wristband is an indicator of impairment, even though there may be innocent explanations there too. It said that the appellate court is not to pick apart the decision or pigeonhole each purported fact as innocent or suspicious. As far as the actual standard of review, it is a question of mixed fact and law. Like I mentioned, are actually going to determine whether the facts were supported by substantial competent evidence. I'd like to point out that last year there was the quite new Casper case, which the district court found that there was not reasonable grounds, but the appellate court disagreed. They said that no, that the officer had reasonable grounds to go ahead and make the arrest, to request testing, all those things, which we thought was the correct answer. But the Supreme Court came back and said, honestly, no. But even though both of you could be right, that the appellate court could be right that there was reasonable grounds, and the district court could be right that there was not. If the district court has a decision that's supported by substantial evidence, it's not a question of whether we should uphold or whether the officer should have initiated an arrest. It's simply a matter of whether the decision made at the district court is supported by evidence. That even if it's not what should have happened or really the correct determination, if it's supported by evidence, it stands. And it indicated that, here we are. In determining whether substantial competent evidence supports the district court's findings, appellate courts must accept as true the evidence and all reasonable inferences, thank you, Judge Warner, drawn from the evidence which support the district court's findings, must disagree with any conflicting evidence. They must give deference to the fact finder.
And counsel, that's different from if we were up here reviewing a criminal case, right?
Yes, Your Honor. Additionally, we're not proving beyond a reasonable doubt anything. This is a probable cause determination of whether it was right to make an arrest. And even before that, it's a reasonable suspicion to actually initiate the investigation. This is definitely not a criminal case.
Well, my question was more if ordinarily in a criminal case, if we're looking at reasonable suspicion or probable cause, we do review that for a totality of the circumstances, right? And that's different here in this case. Correct?
Correct. We can still look at the totality of circumstances, but it's not our burden. And additionally, there is the deference given to the lower courts. Additionally, Your Honor, I'm looking through the rest of my brief. I can go through each one of the indicators of impairment and provide cites for them. But honestly, unless there's additional questions, I can probably just refer to my brief for the remainder of this. Unless you wanted to ask me about Jarvis.
Are there
I'd
any
love to talk
questions?
about Jarvis.
All right, I see no questions and I hear no questions. So, Mr. Bradley, thank you very much for your argument. Appreciate
Yes,
it.
sir.
Mr. Walter, you've got 1 minute to bring it on home.
I don't think we have to give deference to the findings of the district court, Court of Appeals. I cited Sloop in my brief where the district court upheld the administrative law judge. The Court of Appeals upheld the district court, but the Supreme Court said, no, we don't have to give deference. Essentially said we don't have to give deference to the findings of the two lower courts. We can make our own determination based on the facts. And I'm saying the facts of this case indicate that while, as Mr. Bradley says, the officer thought there might be an indication of criminal activity, might be is not enough. Might be is simply reasonable suspicion. It's not probable cause. If you look at the totality of the circumstances and you remove the wristband from the equation, I don't think there's enough here for probable cause for the officer to request that the driver take an evidentiary test. I concluded, Your Honor.
Okay, very well. My thanks to both counsel. Appreciate your arguments very much. And that is the end of our docket for this morning. And so we will be in recess until this afternoon. Thank you all.
Thank you, Your Honors.
Thank you.